Ladies and gentlemen, boys and girls, it's Diego with another fantastic video for you guys out there in K1 visa green card land. Remember, I'm not an immigration attorney. I don't work for USCIS. I don't give you any legal advice, but I do have 13 years experience. 13 years I've been processing green cards in K1 visas, including my own beautiful wife, Karina from Caracas, Venezuela, who recently filed for her 10-year green card. I brought her to the United States from Bogota, Colombia, where she'd been living for 6 years. And we dated for 3 years in Bogota. Now, this video is about USCIS Form I-130, which is a petition for an alien relative, okay? It's a petition for an alien relative. So, this USCIS form is used to prove a qualifying relationship, okay, between a family, between a U.S. citizen or a lawful permanent resident and a foreign family member, which could be your husband or wife who's living overseas, now, or in the United States. Filing this form is the crucial first step in sponsoring an eligible relative for a U.S. green card, and consular processing will be held at an embassy or a consulate overseas. Okay, now, primarily, if you want to get it, right? Now, Form I-130 should be filed as soon as possible to establish a qualifying family relationship and secure a priority date for immigration processing. But you don't need to secure a priority date if you are married to a foreign national. There's no limits on the number of spousal visas, or if you're bringing mom or dad over or a child, okay? But you got to consider the key timing, the considerations for timing. If you are filing for an immediate relative of a U.S. citizen, like your wife or husband, or an unmarried child under age 21, or your mom or dad, you should file the I-130 as soon as the relationship is established. You can prove it. Now, visas for immediate relatives are always available. So if you're bringing your husband or wife to the United States, there's an unlimited number of visas. So the processing time is going to depend on USCIS workloads, etc., and also the embassy workloads and consular workloads. So who can file Form I-130? Let's go into who can file Form I-130. So you must be a U.S. citizen, a U.S. national, or a green card holder to file for this petition. This video is primarily concerned with American citizens, though, not green card holders. So you are the petitioner, and your relative is the beneficiary, and depending on your immigration status, you can file for the following relatives: U.S. citizen spouses, husband and wife, which is what this video is concerned with, or unmarried children under 21, or unmarried sons and daughters 21 or older, or married sons/daughters of any age, and parents. You can bring mom and dad to the United States if the petitioner is 21 or older, and siblings, brothers and sisters, and they got to be 21 or older if the petitioner is 21 or older. Now, if you are filing for an immediate relative of a U.S. citizen, like your husband or your wife, or any unmarried children under 21, or your mom or your dad, you should file the I-130, like I said, as soon as you've established the relationship. Visas for immediate relatives are unlimited. There's no numerical quota on these. So the processing time, like I said, depends on what the workload is at USCIS and at the various embassies. Okay. Now, I'm not going to get into green card holders applying Form I-130. Okay. This video is primarily based upon U.S. citizens who are married to foreign nationals. Remember, though, you must file a separate Form I-130 for each eligible relative, except for unmarried minor children, who can apply alongside their parent as a derivative, just like when you file for a K1 visa. The same applies for the I-130. If you can include the child on the paperwork, okay? And the spouse beneficiary requirement is, if you are filing for your spouse, your husband or wife, both of you must also complete and sign a Form I-130A, which is a supplemental information form for the spouse and the beneficiary. Form I-130 and Form I-130A. if you are married to a foreign national. Now, if you're going to file for your spouse, your husband or wife, he or she must complete and sign Form I-130A. And if your spouse is overseas, Form I-130A must still be completed, but your spouse does not have to sign the form if she's far away from you. But Form I-130A must be submitted with Form I-130. Very important. Now, you understand what forms you got to file. You got to make sure you're in a bona fide relationship, especially for marriage-based petitions. You must provide overwhelming and substantial evidence that the marriage is genuine and not a fraud just for a green card. You're not trying to get somebody over here just to give them a green card. You got to have overwhelming evidence of your relationship. You can include in your paperwork like joint leases, joint bank accounts, photos together, etc. Now, it may be hard to get a joint bank account with a foreign national who doesn't have a social security number, but you still have to prove overwhelming evidence of commingling of funds somehow. Now, it is important to understand that the approval of a Form I-130 only establishes your connection to this person. It doesn't grant your relative any legal status, okay, or work authorization or a green card. Once USCIS approves the petition, it doesn't mean that you have legal status. Not yet. Now, the next steps depend on the beneficiary's location, right? Depends on where she lives or he lives. If you're inside the United States. Now, if a visa is immediately available, the relative may apply to adjust their status to permanent resident by filing Form I-485. But if you came in on a tourist visa and try to do this, there's a very good possibility you're going to be told to return to your home country to process the paperwork. Okay, this is called concurrent filing. If you file the I-485 with the I-130, now that's if you're inside the United States. Okay, if you are outside of the United States, which is preferred by the USCIS folks, the approved petition moves to the Department of State's National Visa Center, the NVC, which is in New Hampshire, for consular processing. The NVC will schedule the visa interviews for you at the embassy or the consulate. Okay, your relative, your husband, your wife will eventually get an interview at a U.S. embassy or a consulate to receive their immigrant visa processing. But you got to upload documents to the National Visa Center to get documentary qualified. The filing fees and the processing times, today is June 15th, 2026, and the filing fee is $625 for an online submission, $675 for a paper submission. But that price can change. That price could already have changed. Okay? So make sure you get the correct cost before you pay. Processing times vary greatly. Immediate relatives like your husband or your wife or minor children or even parents of U.S. citizens, they will usually experience a shorter wait time, say between 6 to 15 months as of June 15th, 2026. Now, if you're going to file an I-130 for other relatives like your brother or sister or married adult children, this wait time could be years due to annual visa caps. Okay? Could take a long time. And to find the most accurate current fees and processing times for your specific situation, check the USCIS Form I-130 page. Go and check out the cost. Now, if you're thinking about sponsoring a relative, I can help you understand the process a lot better if you tell me what your current immigration status is. But if you're watching this video, primarily you're going to be a U.S. citizen married to a foreign national trying to set up an interview overseas at a consulate or an embassy. Okay? Or if you wanted to bring mom and dad to the USA, I can help you with that. Or any unmarried children under age 21. Okay? So, to sum up this video, to file a Form I-130, you're going to be petitioning for your husband or wife. Okay? You need Form I-130 to file for an application for your husband or your wife or under 21 unmarried children, or mom and dad. Okay. If you're filing for your spouse, you got to fill out Form I-130A also as a supplemental form. So you need Form I-130, I-130A. All right. And you got to make sure that you have overwhelming evidence that you are a U.S. citizen. You got to make sure you file overwhelming evidence for this application. When it gets to the National Visa Center, you're going to have to upload specific documents to get documentary qualified also. You got it? Like your certified copy from the courthouse of your marriage certificate. You're going to have to upload your tax returns, pay stubs, a biographic page of everybody's passport, the husband and the wife's passport, biographic page in color. You got to file a separate Form I-130 for each eligible relative, including children. But in this case, let's just make it like you're just married to a foreign national and you're bringing your husband or wife to the United States. This form is going to collect information about the petitioner. It's going to collect information about the beneficiary and the nature of your relationship, husband and wife. So you file the forms, you file the evidence, the overwhelming evidence, and then it goes to the National Visa Center where you have to upload paperwork to get documentary qualified. And then the National Visa Center will schedule the visa interview for your husband or wife, whether it's in Colombia, Argentina, Peru, Pakistan, wherever Egypt, wherever the case may be. Now, the spouse must complete and sign the form even if they are overseas. So if the spouse is outside the United States, they don't need to sign Form I-130A, but it must still be submitted with Form I-130. Okay, you got to prove that you're a U.S. citizen or a green card holder, but we're talking primarily about U.S. citizens married to foreign nationals. You got to have a valid U.S. passport or a naturalization certificate or certificate of citizenship or a consular report of birth abroad to prove your citizenship status and proof of the relationship. Okay.
Hola.
So what's the number one thing you're going to include? Well, the marriage certificate for spouses, birth certificates for children, or other evidence establishing the qualifying relationship. The marriage certificate must be certified by the clerk of the court if it's done in America, or a certified marriage certificate if you got married, like say in Colombia or somewhere like that. If you have terminated prior marriages, you got to have certified copies of original divorce decrees or death certificates for both petitioner and beneficiary, if it's applicable. You cannot make a copy of your divorce decree on a printer. It's got to be certified by the clerk of the court. You need to include 2 identical passport-style color photos of both the petitioner and the beneficiary, 5 centimeters times 5 centimeters, taken within 30 days. And you got to prove that they were taken within 30 days by including the receipt with your paperwork. And if you have any foreign language documents, they must be accompanied by a full English translation certified as complete and accurate. And I recommend the Spanish group in California to certify your documents. They don't pay me to say that. And each beneficiary requires a separate Form I-130. U.S. citizens, which is what this video is primarily directed towards, must file the forms with USCIS either online or by mail. I recommend you file by mail. That way you have you can track it much better that way. And there's less chances of errors. And follow the instructions on the USCIS website. You got it? Very easy, right? The filing fees must be paid as specified by USCIS, and they can change, okay? And if the beneficiary is already in the United States, they can file Form I-485 later on, which is to apply to register permanent residence or adjust status. But if you came into the United States on a tourist visa or a student visa or a work visa, those people are now being told to return to their home country to adjudicate their case for a marriage visa. Okay? And like I said, you can get detailed instructions and download the forms, etc., visit the official USCIS website and their forms to get the Form I-130 and the instructions. Now, the Form I-130, like I said, you can file online or through your USCIS account, or you can mail it, your documents, to the appropriate lockbox based on the state of where you live. I recommend that you mail in the evidence with UPS, DHL, or FedEx. Don't use online portals. They have a tendency to make mistakes. And you can file the Form I-130 electronically by creating a USCIS online account. Okay? But like I said, I recommend the paper way to do this, the old-fashioned way. Complete the form and or upload the supporting documents, pay the filing fee, and you can pay the filing fee with a credit card or a debit card. I recommend you use your debit card, Form G1650. Okay? Use Form G1650 to pay for all visa immigration benefits. And then you can track your case and get confirmation of your case. Submit the Form I-130A for a spouse beneficiary if it's applicable, even if they are living abroad, which will be, in most cases, they will be in this case. And before filing, ensure that you meet the eligibility requirements and you have all the necessary supporting documents ready. And like I said, this includes proof of your U.S. citizenship and evidence of the family relationship. That's it, ladies and gentlemen, boys and girls. And if you want to be able to talk to me, or if you want to call me, text me, email me, join as a member down here somewhere. You can join as a member for $9.99 a month. And to our fellow members of this channel, we appreciate your support. Thank you for your support. And I will pull you over the finish line and get you through this process. And if you join as a member, once you've been a member for 5 months on the channel, 6 months, say 5 or 6 months, Karina, my beautiful wife from Venezuela, will mail you a free bag of her coffee with her face on it. How about that? Free bag of coffee if you've been a sustaining member for 5 months or longer. I do a live stream Mondays, Wednesdays, and Saturdays at 6 p.m. Central Time. You can join us on the live stream. And be patient during the process. Don't panic during the process. Make sure you qualify for the benefit. And remember, you don't need an immigration attorney to do this. It's very easy. And if you still need a little bit more reassuring on how to do it, and you need coaching a little bit, just join as a member. Then you can call me, text me, or email me. See you at the next live stream. And hang in there.
I'll be back.